the North Carolina Supreme Court won't let a golfer revive his suit, alleging that another golfer and the city that owned a driving range are liable for injuries that he sustained when he was hit in the eye with a ball. The court saying his claims are blocked because of his own negligence.
Yeah, joining us now, our chief legal analyst, Khalif Rhodes. Khalif, the group was all drinking beer and moonshine. They finished their round. One goes home, the rest go to the driving range. One buddy stays in the cart, two go up to the driving range. The guy in the cart ends up getting hit by a golf ball, hit by one of his friends. And the justice said, and the majority is like, no, man, you could see the driving range. You're negligent. What do you think?
Friendly fire. It seems like that's what occurred, right?
Yeah.
And obviously no joking matter at all. Getting hit in the eye with anything is going to hurt. A golf ball traveling at any type of speed. I'm assuming that his friends were decent golfers if he sustained some type of injury.
Maybe not if they hit him.
Right. Well, you never know, right? They may have been aiming for him. But seriously, this right here is a couple things. You guys in the last hit talked about taking you to law school. So we'll go back a couple of steps and talk about some of the things that the court talked about. You file your complaint in district court. District court rejects and dismisses your claim on something called summary judgment. That's basically the court saying you've filed this complaint, the defense has responded, and because they've responded in a manner which defeats a number of your claims, your case isn't even going to move forward. You filed it, but you can't get an opportunity to get it in front of a trier of fact, a jury, or someone to listen to this case. So it's dismissed. They appeal, go to the Court of Appeals. Divided Court of Appeals make the determination and agree with the lower court. So what do? You appeal to the Supreme Court. Supreme Court of North Carolina unpacks and addresses this on a couple of things. We talk about something called contributory negligence. In negligence claims all the time, duty, breach, causation, damages, right? Just like injunction has those four elements, a negligence claim has those four elements. But in North Carolina, it's only one of the 3 states that have this contributory negligence. Most states have something called comparative fault. If I'm at fault, say 2%, then I can go and recover 98% of my claim against the person, and 2% will be barred. North Carolina is not like that. In North Carolina, if I'm 1% at fault, now I am barred completely from bringing any claim for you for the 99%. Yeah, your reaction is the same as mine. Extremely weird. When you learn about it in law school, you're like, definitely not going to North Carolina, and somehow I still landed here. But at the end of the day, I will say those are the types of things that stop his claim, because first of all, it's contributory negligence, and then it's open and obvious, and that's what the judge talked about. If you would have looked up from your phone, is what he said. If he had looked up from the phone, plaintiff would have seen that he was sitting a mere 30 yards or so downrange from the tee-off area. It's an open and obvious situation that you should have been aware of, and because you were busy texting and not looking, your contributory negligence to your own demise, no recovery.
I would have never parked there because I've seen Julian slice. I know it's going to be hooked.
I would have said you were in danger.
Yeah, I know exactly where to go. 300 feet behind Julian is the key. All right, so when you're talking about this contributory negligence, it's almost as if the courts are saying, hey, when there's a recreational setting, you're responsible for your own safety. Is that already the case for most recreational type activities in North Carolina? Is this changing or setting a precedent for who's responsible?
Not limited to recreational. This is any type of situation where you get in a car accident, for instance. If I'm driving down the street and you hit me, but I maybe was a little bit further out past the stop sign than I should have been, you clearly still T-boned me.
Or on the phone.
Right, but I wasn't paying attention. That small amount of contributing to my own demise is what the court takes issues with. And again, this is one of 3 states that has it, something that other states have gotten away with because it just it takes away what you think would be logical. Okay, remove the part that I'm at fault for, but don't bar me from getting an opportunity to hear it. One of the justices, I should say, too, Justice Anita Earl and Justice Allison Riggs, who we've talked about a number of times in the past, who had to fight just to get to her seat, they both dissented, saying that, listen, we think this is a question that the jury should have an opportunity to hear. Because remember, this court didn't decide the underlying case. It just says your case can't go all the way to a judge or a jury to make a determination.
Real quick, do you think it should have gone to a jury? Because, I mean, again, if you're in a driving range, right, there's a reasonable expectation that the people are going to hit the balls into the driving range, not at the cart.
Well, the issue with that portion of it is it a dispute of material fact? That's the question that the court has to answer. Do we believe that the cart was in the right location, or was it moved? Did it move 90 feet, as they said, between, or 90 seconds before the ball was hit? That's a question of material fact. That's a question that you would want a jury to make a determination of. And if the jury says, you know what, it wasn't moved or it was moved, okay, then we're going to allow that contributory negligence to come in. But to take it away from the jury, and that's what Justice Anita Earl said, she thought that was a step too far. This should have went to jury and allowed them to make a determination. So, I mean, but the biggest thing I can say is don't play around on your phone, because these justices that are listening to these cases, they're not texting or playing video games, so they don't even understand how much time we spend on these devices. He's like, that's normal. They're like, maybe not so.
Oh, this is not the last we've heard of that for sure. All right, Khalif, thanks. Appreciate it.
Queen City News Plus. Just search Queen City News on your smart TV's app store.